Good morning, everybody, and thank you for joining us. Before we start today, I'm just going to run through a couple of housekeeping information. Thank you to those who've already submitted questions. We will go through them towards the end. If you would like to submit a question throughout, you can do so via the Q&A function on your screen. We will be recording the webinar today as well, and we will be sending a copy out to everyone afterwards. We were meant to be joined today by two presenters, but unfortunately, due to a couple of technical issues, we will now only be joined by Nicola. And on that note, I will hand over to Nicola.
Thank you, Lisa. Morning, everyone. I'm a partner here at IM in our will, trust and estate disputes team. In addition to perhaps the more conventional trust and estate disputes, I have a strong practice involving vulnerable litigants and complex capacity issues. And capacity issues certainly crop up in the context of private wealth and in the matters we're going to be focusing in on today, which are financial abuse and undue influence. I'll also touch on trustee duties because I think they're also relevant. I'm also currently litigating a matter concerning a very elderly gentleman of significant wealth, and there is a real concern that he lacks capacity to manage his finances and that his wealth is the subject of significant abuse in the sums of well, in £1 million sums. So I've got quite a lot of recent experience of this type of issue in the context of the pandemic, which I think would be helpful, and I will be mentioning that as I go along today. The issue of the wealthy vulnerable being subject to financial abuse is an existing and long-standing problem, and I think the current situation only compounds that problem. So today I'm going to discuss initially the pressure points that the pandemic will bring to bear on these particular issues and what practitioners might need to look out for. I will then look at undue influence and the legal test for undue influence before moving on to the application process if you want to apply or a relative wants to apply to become a deputy or someone is considering making an LPA. And I will then look at the removal of an attorney and deputy if someone or you have concerns about an incumbent deputy or attorney and the way that they are managing a person's finances. And then I'll round up with a summary of trustee duties and how they might be affected by the pandemic. So looking at the pressure points first, if I just move on, move the slide on. So many people, of course, have lost their jobs or are becoming increasingly under more and more financial pressure. And I think some may look to a wealthy relative as an answer to those financial difficulties. And older people at the same time are shielding completely. I know I haven't seen my mum since the 7th of March. My brother delivers food parcels to her. She's totally hibernating. And this is, of course, the norm for those who are older. And I'll use the word older rather than elderly, because I think if my mum ever hears this, she won't take very kindly to me using elderly and her in the same context. She's also struggling with the isolation. I think most of us are still going out for runs or popping to the shops. Well, at least I am. And I think that that's right for the majority of sort of healthy people in the UK, whereas the elderly are shielding entirely, and at the same time those people are becoming more dependent on others. And I think it's fair to say that like us all, but perhaps exaggerated in that particular bracket, are struggling emotionally, and at the same time there's a relaxation of usual procedures, and while that might make sense and modifications do need to be made to meet the new needs that the pandemic is bringing, that relaxation is creating new opportunities to exploit those who are wealthy and vulnerable, or at least the latter are going to be hit the most. And I think that these all of these factors coming together, I think, will inevitably manifest in an increase in fraud, duress and coercion. And we as practitioners need to be live to these issues so that we can protect our clients. So I'm just going to now turn to those modifications to standard procedure. First of all, I want to look at the guidance from the Office of Public Guardian. And I think we've got some on the webinar today. And the Office of Public Guardian is the government body who protects the assets and supervises the financial affairs of those people who lack capacity to make these decisions for themselves. They published guidance on the 17th of April this year called Short-Term Options for Health, Welfare and Financial Decisions. And the thrust of that guidance is essentially that it's fine, given the circumstances, to appoint someone else to access your money and manage it on your behalf. And specifically, it's recommending two arrangements. Firstly, if you are a shielding or self-isolating person, to execute a third-party mandate, which allows you to authorise someone else to carry out your bank transactions for you. And secondly, to consider a general power of attorney to authorise someone to manage your financial affairs on your behalf. A general power of attorney is not one that's predicated on you losing your capacity, necessarily like an LPA, but a general one that simply allows you to delegate your business to someone else. And these arrangements, of course, encourage people to trust others. And as I have identified and really pitched at the elderly, older people who will not risk that trip to the bank. And I suspect these arrangements will likely become the new norm and the restrictions endure. And while I entirely understand the OPG's guidance from a practical perspective, I am concerned about the promotion and use of these types of arrangements because they do, I believe, inevitably increase the risk of financial abuse to those who are wealthy and vulnerable. The Equity Release Council has also modified its advice on safeguards and is now enabling remote provision of legal advice for equity release customers. And this is a temporary revision to its Rule 8 to enable cases to complete without a physical face-to-face meeting with a solicitor. And this is a relaxation of the usual gold standard of face-to-face legal advice, which has been mandated over the last 6 years. And the other change is this, the mandatory physical witnessing by a solicitor of a client's signature on the mortgage deed can now be carried out by an independent adult witness of the client's choosing, although the Equity Release Council reassure us that they will also be subject to identity checks. But in summary, homeowners can now release equity from their home without seeing a solicitor face-to-face and without the solicitor needing to physically witness their signature on the mortgage deed. It can now be completed by a third party of the client's choosing. The chairman said the council recognised that there is a need for pragmatic, flexible and time-limited alternatives during this unprecedented period of national lockdown. And again, I understand the very practical benefits of these modifications, but it is no longer applying that gold standard, and I think these changes will be exploited. And I know the council promises that there will be sort of this layered protective approach, including remote assessments. But I'm very cautious about remote assessments, especially when it comes to those who are vulnerable or who may lack capacity. And I've had recent experience of this in the context of the case that I mentioned at the outset. I spoke to a doctor with a view to arranging a capacity assessment for that elderly gentleman. And I thought that the court would absolutely not order a one-to-one face-to-face assessment because of the risk of the elderly gentleman contracting COVID. But the doctor was very clear, and he said to me, Nicola, he's not going to understand me at the other end of a phone or computer. He's very elderly. He's not really going to be able to engage with that, and I'm not confident that I'm going to be able to assess him through remote means. He also raised the concern that it can be easily interfered with. It's quite easy to tamper or influence a remote assessment. I mean, he used the example of putting post-its around a computer with the answers on. But he had real concerns about an assessment taking place of a vulnerable elderly adult through remote means, and I think that that's right. So I on the back of that advice from the doctor, and he's a very experienced Court of Protection doctor. He does lots of reports for the Court of Protection. He's also a special visitor through the OPG, and I think that advice is sound. So consequently, due to the sort of combination of factors, the increase in dependency, the shielding, the modifications, the relaxation in standard procedure, I think we will see an increase in cash being taken, property transfers, gifting of valuable items or shares, equity releases, and they will be voidable transactions because so long as it can be substantiated, they were procured by fraud or undue influence. And as I say, this compounds an already significant financial abuse problem. Even before lockdown, which started on the 23rd of March, the same day that I started with IM. On the 9th of March, the Law Society published an article detailing the warning signs of financial abuse and what practitioners should look out for and what steps they can take. And the Law Society, the Law Society reported in that article that over 50s control 70% of the nation's wealth, hence why the impact of COVID could be so significant here. But the message really that came from that article is that solicitors are well placed to identify financial abuse in the context of particular retainers. And also I think the same is true for those in the world of finance, accountants, financial planners, and they're also well placed to identify and spot these problems. Certainly, as regards solicitors, there is a responsibility on them to understand their role in preventing it and to take appropriate action. The SRA Code of Conduct mandates that solicitors act in their clients' best interests, obviously, and to protect client money and assets. So I think professionals do need to be live to these issues so we can identify them and we do know what steps to take if and when something crops up. Some recommendations are obvious. Look out for the estranged relative who suddenly pops up or a new friend or neighbour who's suddenly taking an interest. I think we need to be careful about remote assessments, as I've identified. I think we should try and see our client alone, if possible. We can explain that it's important to see the client alone, to check for reasons of confidentiality, to check the independence of their instructions. It can be couched sensitively, but I think we should do that wherever possible. And we should also bottom out those capacity concerns. And I'll come to that in more detail. There is a definition of financial abuse and it's contained in the Care Act, and it includes having money or property stolen, being defrauded, being put under pressure in relation to money or other property, and having money or other property misuse. So it covers a wide variety of activities, from mishandling finances to a breach of trust or serious fraud on a major scale. So just wanted to touch on undue influence and just take everyone through that today, because I think there's quite a bit of confusion about undue influence. The term is certainly used a lot, and it indeed is a tricky one to navigate. But what it is not is persuading someone. Generally, persuasion is permissible. What it is coercion, which means forcing someone to do something that they would not normally do by making threats of some description. It doesn't necessarily have to be a physical threat, it can be an emotional one. There's also a case which suggests that attrition of someone's will over time may also be enough, but it's got to meet that threshold, and it is reasonably difficult to establish. So I'm just going to look at that legal test to help everyone on the webinar today to understand it better. And it's a two-stage test, a relationship of influence with another and a transaction that has occurred which calls for an explanation. And the general principle is that the person who is asserting the wrong, so the person claiming undue influence, must prove both these elements. In the case of Hackett and the CPS, it's a 2011 case. It was decided that proof that the complainant placed trust and confidence in the other party in relation to the management of the complainant's financial affairs, coupled with a transaction which calls for explanation, will normally be sufficient, failing satisfactory evidence to the contrary, to discharge the burden of proof. So just looking at that test, I look at the second limb first, the transaction that has occurred which calls for an explanation. That's really a matter of fact. Is there a dodgy transaction? So I'm not going to focus on that, but I'm going to just focus in on the first limb of that test, which is the relationship of influence with another. Now, there are specific relationships which automatically meet this test. These include the relationship of trustee and beneficiary, principal and agent, solicitor and client, parent and child. If a transaction is challenged in the context of one of these relationships, the burden is on the adult who is in the position of trust to show that they have acted honestly. So, for example, in solicitor-client relationship, the client claims that solicitor has applied undue influence, then it will be for the solicitor who's in the position of trust to show that he or she has acted honestly. In other cases, it needs to be proven, and that relationship needs to be established by the person claiming undue influence, and they need to establish that there was a relationship of trust and confidence. And once both limbs of that test are satisfied, the stage is set for the court to infer that in the absence of a satisfactory explanation, the transaction can only have been procured by undue influence. And at this point, as I said before, the burden is on the adult who is in a position of trust to show that he or she has acted honestly, and they need to counter that inference, which otherwise shall be drawn. So what do they need to do in order to counter that inference? Well, they'll need to show evidence that the complainant, the person claiming undue influence, wasn't labouring under any undue influence, but they were exercising their will as a result of full, free and informed thought. And that's the 2010 case of Smith and Cooper, i.e. it was their decision that they made of their own free will. And absent that evidence, the court will find undue influence. And a common theme in undue influence cases is what happens if the complainant has received external advice, for example, from a financial advisor or a solicitor on the transaction, whether that's enough to show that they were properly informed and therefore the transaction was a product of their own free will. And the short answer is that isn't necessarily enough. The question still remains, did that have an emancipating effect? And that will depend on whether that advice led to a decision based upon full, free and informed thought. A person may understand the implications of a proposed transaction. for example, making a substantial gift, transferring their property, investing significant wealth in another person's business, but yet they might still be acting under undue influence of another. As I said at the beginning, in light of COVID-19, we have a combination of quite potent factors. Many elderly people in particular are now totally isolated, dependent on others, perhaps to bring them food and medicines. They may also be scared and lonely, and while the majority of people naturally act in good faith, and I've seen lots of community work going on and fundraising for good causes and a real effort to look after those who are vulnerable in society, there will be others who will use the opportunity to apply undue influence, and the wealthy vulnerable will absolutely be most at risk. If undue influence can be substantiated, you can apply to the court for the relevant transaction to be set aside, because it will be voidable by virtue of the undue influence. So many of you know what this means, but it means it can be undone. So if a property has been transferred to another as a result of undue influence, that transfer can be set aside and the legal title can be returned to its original owner. So things can go back to how they were before. And similarly, if a transaction has been or has purportedly been carried out by an adult, but there is evidence that that adult lacked capacity to carry out that particular transaction, again, it shall be a voidable transaction. It's not sort of voidable ab initio. It's not voidable. It's not void from the very start. You have to elect to set it aside and return to the original position, and a court application will likely be necessary to set it aside. And the other issue as regards undue influence that I think we need to be aware of in the current climate is in relation to wills and those using the opportunity to coerce a vulnerable person to either change an existing will or make a will in favour of them, even though the person making the will does not want to, or they perhaps lack the testamentary capacity to make a will. So that's undue influence. I just want to speak to you now about the process. If you are concerned about someone's capacity and their ability to manage their own finances, what you can do, and then I'll touch on LPAs as well, which obviously need to be made while the donor still has capacity. But I'll look at deputyships first. If you suspect that someone has lost capacity to manage their finances, you can apply to the Court of Protection to appoint a property and affairs deputy to look after their finances for them. You need to make an application and you'll need to provide notice to family members and those interested in the person's welfare about the application. I think we received a question in about, well, what do you do in order to establish that lack of capacity in the first place, especially in light of the pandemic and the restrictions which are in place? Care homes are in lockdown and it's not possible to arrange those assessments as it was previously. And indeed, when you make an application to the Court of Protection for a deputy to be appointed, you will need evidence that the person has lost capacity, or there is reason to believe that that person has lost capacity. And indeed, that's the issue that I was faced with recently in the case that I mentioned. While we suspect, we have my client who's a concerned relative of the elderly gentleman, while he has concerns that the gentleman lacks capacity, currently we do not have any concrete evidence from a doctor by way of report that he absolutely lacks capacity. So it's a bit of a sort of chicken and egg situation. We need the protection of the court, but we don't necessarily have the requisite evidence at this stage in order to support that application. So I think my advice in this scenario would really be to gather as much evidence as you can, even if it's not perfect. So you might have somebody at the care home, for example, a nurse or a doctor at the care home, or somebody who's looking after that person who is able to provide some evidence that the part of the adult, the vulnerable adult in question, lacks capacity, or they have reason to believe they lack capacity. They might take notes that are contained in the folders at the care home to suggest that actually this person isn't really understanding things, and they've had conversations with them about their finances and they don't understand certain aspects of the information, or they're showing that they're not able to weigh it up. There should be some evidence available. There usually is. So it's about sort of collating that, the best evidence you can find, and presenting that to the court. The court can then take a view as to whether a further assessment needs to take place. It might be that there's sufficient evidence to make an interim order at least, with a view then to revisiting the issue of that person's capacity after the pandemic, when things are opened up and doctor assessments can take place in the usual form. Or it might be that they do try a remote assessment. In some cases it might work, and it might provide some useful evidence. Again, it's just to support an interim order. And in my case, in fact, the court did in any case order a one-to-one assessment, because it thought that the risk was so serious that outweighed the risk of the gentleman coming into contact with another person and potentially catching coronavirus. So it was a balancing exercise, and the court took the view that the most important thing was for the gentleman to have the protection of the court. So I think, in short, the court is very live to these issues, and I think that it is willing to adapt accordingly and still make those orders, even if it's on an interim basis, in order to afford that person the protection that they need. Now, of course, these applications usually take about 6 months anyway in order to appoint a deputy. So unless you can actually point to a reason as to why something is particularly urgent, I think it would be dealt with in the usual course of things anyway. And I'm sure we can all relate to some of the frustrations in terms of the time it takes sometimes to process an application for a property and affairs deputy. So if the evidence shows that the person, or there is sufficient evidence to show that the person does lack capacity to manage their finances, and there's no objection to the appointment of a deputy, the court can go ahead and make that appointment. A deputy can be a lay person, so a family, a friend, or a professional deputy, so a solicitor or accountant. Moving on to lasting power of touched on that, whether a remote assessment is a good idea or not. Touching now on lasting power of attorneys. So of course, the client needs to have capacity in order to appoint a donee to manage their financial affairs on their behalf. And this is usually done in case they lose capacity to manage their own affairs, but LPAs can also be used while the donor retains capacity. It depends on the donor's preferences and the instructions in the LPA. Solicitors involved in the LPA making process, I think at the moment, should be very careful about taking instructions from a client remotely. As I say, my views accord with the doctors who I spoke to, and that's that I'm very cautious about those remote assessments. And I think wherever possible, we should still be carrying out those assessments in person if possible. I know Sophie, who was going to be on the webinar today, she was going to mention how she's been out actually, and she's sat with donors in their garden, keeping a safe distance and still taking instructions and providing that level of scrutiny. And I think that's something that we are being very careful about at the moment. We need to ensure that the instructions that we receive are a product of a client's own free will, and there's no tampering or influence being brought to bear on that person. And when we do go out, and I think this is a good rule of thumb, full stop, it's important to see the client alone. I think it can be sensitively couched to the client and perhaps anybody who's attending that meeting, that you need to check the independence of your client's instructions. It's important for issues of confidentiality that you just spend some time with that client alone, so you can be really clear that those instructions and their desire to make that appointment is their own. I think it's also important to warn clients of the risk of abuse under LPA, so they're fully informed. I mean, in many ways, a deputyship is more protective. A deputyship requires a deputy to keep accounts, submit annual reports to the OPG to be scrutinised, and they also have to take out a security bond against any loss. For example, in the case of GM 2013, the deputies spent money on cars and watches. Now, obviously, that's not something that's permissible, and the court was able to call in the security bond, which covered the spending, which I think was in the sum of around 275,000, and this would not have been available with the LPA. So that is an advantage of a deputyship over an LPA. And it's also important that attorneys understand their duties, so they know what is allowed and what isn't allowed, because I know in many cases we see situations where an attorney has done something that they thought was okay, and they were perhaps just labouring under a misunderstanding about what was permissible and what wasn't. So I think if all of those issues can be firmed up and clear at the outset, then that helps all parties involved. So what do you do, though, if an attorney or deputy is appointed and you have concerns about the way that they're managing a person's finances? So I'm just going to look at that now, what the remedies are if you are faced with that particular situation. So, for example, if you have a concern about an attorney, the way that they are managing a protected party's money or property, you can report your concerns to the Office of Public Guardian. They are able to open an investigation and scrutinise some of the documents. And what have I done? Oh, I've gone. Excuse me, everyone. Just go back slightly. There we go. So the OPG can investigate and provide provide the outcome of that investigation, and that will then inform next steps, and they can also escalate things to the Court of Protection. But I just want to pause there for a second and just explain that attorneys and deputies are, of course, fiduciaries. The trustee, beneficiary, solicitor-client relationships are examples of automatic fiduciary relationships as well. They've undertaken to act for and on behalf of a donor or protected party in circumstances which give rise to a relationship of trust and confidence. And the distinguishing obligation of a fiduciary is one of loyalty, and the core obligation has several facets. A fiduciary must act in good faith. He must not make a profit out of his role or the trust that's been placed in him. He must not place himself in a position where his duty and his interest, his own personal interest, conflict, and he may not act for his own benefit or for the benefit of a third party without the informed consent of his principal, or in the case of an incapacitated principal, the Court of Protection's authorisation. So as I say, if you have concerns about an attorney, you can report them to the Office of Public Guardian. You can also ask or demand that the attorney produce an account of how he has managed and applied the money, details of any remuneration or expenses, or to supply any information or record in his possession. And the ability to demand that information is contained in Section 23 of the Mental Capacity Act. Section 22, 4 of the Mental Capacity Act allows the court, if the donor has lost capacity at this point, to revoke an LPA if the attorney has contravened his authority and the court decides it's no longer in the incapacitated adult's best interest to have the LPA in place. And of course, if the donor retains capacity, he can of course revoke the lasting power of attorney at any time. Now, if you're dealing with a deputy and not an attorney, that's slightly different because again, you can report your concerns to the OPG, but a deputy is required to submit an annual report to the OPG, which is scrutinised. So there's already, with a deputyship, an inbuilt layer of protection. So the OPG should arguably be aware without necessarily needing to receive a report. But obviously, a deputy not acting in good faith, of course, the vast majority are, but we're not talking about those. The report may not be an accurate reflection of things that are on the ground. So it's not watertight. It certainly offers something, and it does have superior layers of protection compared to an LPA, which doesn't really have any checks. But there's already that in place. If you have concerns about the deputy, you can apply to the Court of Protection for the deputyship to be revoked, or you can ask the court to vary the powers conferred on the deputy. And the court will do this if it's satisfied that the deputy has behaved or is behaving in a way that contravenes the authority conferred on him by the court, or is behaving in a way that's not consistent with the incapacitated party's best interests, or is proposing, so threatening to behave in a way that would contravene his authority or the protected party's best interests. It's important to note that an application can be made by anyone interested in the protected party. So if you can show that you have a genuine concern for the welfare of a protected party, you're likely to have standing in order to make that application, and that's the case of B and RC 2011. So what might meet threshold for either the revocation of an LPA or the removal of a deputy? And one does need to consider carefully whether the behaviour in question is serious enough for the court to take that serious step of removing a deputy or an attorney. And at a minimum, you will probably need dishonesty, gross negligence, and or a dereliction of duties. So I'm just going to run through a few cases where the circumstances did meet threshold. The first one is the case of Re Harcourt, 2013. Concerns had been raised that the attorney was not managing their mother's finances competently or with integrity, and the OPG quite properly opened an investigation, but she deliberately obstructed the OPG's investigation and failed to comply with the court order. And Senior Judge Lush, in that case, ordered that the LPA was to be revoked and a deputy, I presume a panel deputy, but I'm not sure, be appointed to manage Mrs. Harcourt's affairs. So the message from that case is obstructing an OPG investigation will do it. In Re NC 2015, the court removed one of two attorneys, and this was because, as regards this particular attorney, there was evidence to suggest that she'd spent substantial sums of money on herself, while simultaneously letting NC's care home fees fall into arrears. And she was removed, but the other attorney was allowed to carry on as sole attorney. So the court didn't just revoke the LPA in its entirety, it simply removed the bad attorney, as it were. And the factor of magnetic importance in that case was about respecting MC's wishes as had been expressed in her LPA. So while one of the attorneys was not allowed to continue, the court took the view that there was nothing stopping it from honouring MC's wishes in respect of the other attorney MC had chosen. As I mentioned before, in re-GM 2013, the deputy spent money on cars and luxury watches, and unsurprisingly, that's definitely a no-no. In the matter of JM 2014, JM sold the Donors house for $165,000 and placed the net proceeds of that sale into JM's own bank account, although once JM had got wind of the OPG's investigation, he quickly transferred that money into an account he'd then opened in the donor's name. Albeit unsuccessfully, he tried to persuade Aviva to transfer the donor's investment bond into an account in his own name. 3, he made a gift to himself of $38,000. 4, he was unable to account for drawings over $10,000, and 5, he'd been paying himself a salary for his work. And unsurprisingly, Senior Judge Lush again concluded in that case that he was plainly in breach of his fiduciary duties as an attorney, and he had behaved in a way that contravened his authority and not in the donor's best interests, and he revoked the LPA. And I think in practice there's going to be a lot of middle ground, so they are perhaps sort of fairly straightforward examples of what's not allowed. I think probably most of us could look at those and say, no, that's absolutely not permissible. And there's going to be a lot more that are in that middle ground where you're likely going to need to take advice on what to do in those circumstances. Just now moving on to the last part, as I say, because we've been looking at fiduciary relationships, I wanted to touch on trustee duties during these difficult times. It's something I enjoy, albeit I tend to deal sort of when things go wrong in breach of trust situations, and this subject could take up probably a webinar in itself, and I'm not necessarily sure on the back of this whether I'll be back by popular demand, so I'm just going to touch on it today, just really to flag where the pressure points are. So the first one, what happens if a trustee falls ill with COVID-19? Now, the ability for trustees to act unanimously if one falls ill with COVID-19 is of course going to be hindered. Given trustees are usually required to act unanimously, there could be significant problems for the day-to-day running of the trust should one of the trustees fall ill with COVID-19. And one needs to be mindful of this eventuality, and likely the best way to mitigate this risk would be to put in place trustee powers of attorney. Although trustees cannot always further delegate their powers conferred on them unless it's expressly permitted under the trust document. So that's something to check, but there should be a plan in place as to what could be done if that eventuality does unfortunately arise. I also anticipate that there will be more complaints in relation to high trustee fees, reduced distributions, the financial performance of assets. So at this time, if you are a trustee, I would suggest you quite sensibly increase your contact with your beneficiaries to reassure them that you are reacting appropriately to the circumstances to preserve the value of the trust assets. given, so to go the extra mile, I think would be my sort of key message at the moment in the context of the pandemic. And given the economic downturn and recession, which I think is inevitably in prospect, and maybe we're in the calm before the storm at the moment, I don't know, there's lots of uncertainty. But trustees may be concerned that they're going to be personally exposed as a trustee if the value of the trust assets depreciates. And for this reason, I would advise, or I certainly suggest, that it's important for trustees to continue to and show and demonstrate that they have continued to act in good faith and have acted proactively in the interest of the beneficiaries. They don't just sort of sit there and do nothing. Make sure that you're doing everything that you possibly can in the circumstances, and then you should have a reasonable defence to any allegation of breach of trust. I mean, the level of reactiveness that's required as regards the underlying trust assets will obviously vary from trust to trust, but I think for now that's a good starting point and a good rule of thumb. So you're sort of shoring up your position now, that you've done all that you can, and that you have acted proactively in response to the situation. And that concludes my presentation today. I hope it's been useful. If you've got any questions, please do send them through. I know there was a couple of questions that were sent through before I started today. I think I've answered the one about what could be done as regards capacity assessments while in lockdown. I think I answered that earlier. The other question was, do I feel that there's an increase or increase in abuse or less abuse at the moment? I think the short answer to that is I don't know. There's not been any formal testing of any sort on that front. I think priorities have been elsewhere. But I think what I would say is, for the reasons I've outlined at the beginning of this presentation, I think there's a real risk that they will increase, and I think that we will likely see an increase. Somebody's asked about good practice guidance from the Law Society or the SRA detailing what solicitors should do. That's yes, there is some really helpful material on that, and I will make sure that that's sent through to you at the end after this presentation, because the Law Society has some really helpful practice. It has a helpful practice note on financial abuse and what to look out for. Lots of practical stuff that will help practitioners. So I'll make sure that that link is sent to you after this presentation, so you have the benefit of that. And that's what I would probably signpost you to in the first instance. In terms of the SRA, it's a code of conduct, really. That's there's sort of nothing really in addition to that. As I say, that the two principles that I flagged earlier were to act in the client's best interest and to protect clients' assets. And I think under those sort of principles and those umbrellas comes with a responsibility to look out for all of the issues that I've sort of been through today. And I think that's it. If anybody else has got any further questions, I'm very happy to take them if you want to ping them through. And I can wait a second in case anybody's got any further questions. No? Well, I think that concludes today. I hope that it's been helpful. If anybody wants to get in touch with me to discuss anything specific, then they're very welcome to. I would also signpost you to our coronavirus hub. There's an abundance of really helpful information on that hub in lots of different areas, so I'd really encourage you to have a look at that. And that's my email address there in case you wanted to ask me any questions after this presentation, or you wanted to get in touch about anything specifically. Otherwise, thank you very much for joining me today. I'm really grateful, and hopefully I'll see some of you soon in person. Thank you.